Good morning. I welcome the first panel of witnesses to the meeting, Right Honourable Lord Hamilton, Lord President and Lord Justice General, and Ms Eleanor Emberson, Chief Executive of the Scottish Court Service. Welcome to you both this morning. And I understand not only must the Lord President be away at 10:30, therefore I warn committee to get into short, sharp questions. But secondly, I think Lord President would like to make a short opening statement, and be most obliged if you would, please.
Thank you very much, Madam Chair, and good morning to you and to the other members of the committee. I'd just like to say one or two words in opening. Thank you very much for your invitation to me to give evidence before you in relation to this matter. I think this is a very opportune time for an event such as this. The Scottish Court Service, which I chair, has now been in statutory existence for just a little over 18 months, and it is beginning to find its feet, and indeed I think it might be said already to have found its feet. It's of course now is facing and is about to face very marked restraints so far as public expenditure is concerned. And doing these two things with the Scottish Court Service in its present form and facing up to these challenges is an opportune stage at which to look at how things are going. The Scottish Court Service, of course, is a creation of the Scottish Parliament. It has a very interesting mix of board members, the majority of members of the judiciary from all levels, from the Lord President down to a member of the justices, and it also includes the Chief Executive, 2 members of the legal profession, and 3 members from the community at large. So it brings together a wide perspective of different experiences, and although the individual members of the board don't represent any constituencies as such, they bring their experiences from particular areas of life to that matter. And it's worked very well, and the members have gelled well, and we believe that we're moving forward. I think it might be said that we have acquired a certain status, partly because of our constituency, our constitution, and also because of what we've been doing. And that's given us a degree of influence, I think, with government, which perhaps the agency which preceded it didn't have, and we're grateful for that state of affairs. The Constitution drew its inspiration from matters across the Irish Sea in the Republic of Ireland when they set up a similar establishment in their days of plenty in the 1990s. Of course, there are other days of famine now, but they set it up in good economic times. We've been set up in rather challenging economic times. I don't complain about that, because in some ways the existence of challenges imposes a certain discipline on public bodies. It means you have to look carefully where you can best deploy the public resources that are provided for you. We've got a number of challenges in front of us. Some of them include the fact that we are only part of the justice system as a whole. Other bodies such as the police, the Procurator Fiscal Service, the community service organisations and the like all have their respective parts to play. We cannot on our own secure necessarily the most efficient arrangements so far as the processing of court cases are concerned. We need cooperation with them. We're seeking that and we're getting that, and matters are moving forward. One of the matters that I mentioned when I opened the Scottish legal year in September, as I had done the previous year, was a matter which is conventionally called churn. That is to say, where there is inefficiency in the processing of court cases. Various steps are being taken, which we'll no doubt come back to in due course in relation to that matter, but we think we can tackle that aspect of matters and to make some progress in relation to avoidance of waste of court time. So with these few words, I'm happy to take any questions the committee wish to have.
I think I'll just simply say, first of all, as you mentioned, churn, what can be done to prevent churn in the system?
Well, I think a lot of it depends on parties other than the court. One of the worst areas of churn is in relation to summary criminal cases, cases coming for trial and parties not being in a position to proceed to court in that regard, either because of witnesses not being present or for some other reason. The Procurator Fiscal Service with the police are doing something about that, at least in pilot schemes, in that they're now sending out the modern thing called a text message to witnesses the day before, reminding them that they have been cited to give evidence and that they are expected in court the next day. They also have an arrangement whereby if the witnesses haven't turned up when they're expected to turn up for the court, they will send the bobby out to get them and bring them to court. And that, I think, is working, and it's to be hoped that that will be done over the peace. At a high level, in the High Court, we're concerned to some extent with preliminary hearings as to whether they're as efficient as they might be, and I've now made an arrangement whereby we're going to have these dealt not with by all the judges, but by a small group, a cadre of specialist judges to deal with that matter. So the court has some powers. It hasn't a great deal in the way of sanction it can impose. If people don't turn up with their witnesses in time, they can make noises and so forth. But there are certain measures that we can take.
Thank you. The other members, in John Lamont, will be followed by James Kelly, Roderick Campbell, and then Hamza.
Thank you, Convener. Good morning to you both. My question relates to court locations, and in your submission you set out a process, or you described a process in terms of reviewing the number of courts. I just wondered if you could set out the time scale for consulting on these proposals and when you actually think they will be put in place, put into practice.
Well, we're at a very early stage at the moment. Perhaps I should introduce my response by saying that so far as the expenditure of the Scottish Court Service is concerned, 40% of that expenditure is on court buildings. Another 40% is on the wages of staff, and then there's a balance of 20%. So a very large amount of our court expenditure is on actually maintaining of buildings. Some of these buildings are rather old buildings, and therefore the maintenance costs are increased. What we've begun, and we're only at a very early stage of it, is looking at the question as to what we really want by way of the provision of court buildings in the 21st century. Most of them, as I say, are 19th century, and they were created and built at the particular places they were created because of the state of the community at that time, including questions of travel and so on and so forth. So we're looking at the matter really fundamentally. We're at the stage at which it's been brought before the board on one occasion with a preliminary paper prepared by one of the officials. The board took the view at its last meeting that the appropriate next step was to get the judicial members, and particularly the Sheriff's Principal and myself and the Justice Clerk, to look at what principles we ought to be applying in relation to the provision of court services in the future. And we are taking that forward, and we hope to be able to report to the board at the next meeting, or perhaps the meeting after next, in that regard. We've already taken some soundings in relation to affected people, such as the judicial office holders, members of the court service, as to say, members of staff of the court service, and so forth. We would hope to be able to go out to a wider consultation sometime early in the new year. But that's about the best I can say insofar as timetable is concerned. So far as implementation is concerned, that is some distance down the line. One thing that we are doing, and we have done, is we've addressed the question of what we call split sites. That's to say, if we have in the same town or city both a sheriff court and a justice of the peace court, what are the options of actually combining these into a single building? And I think in 4 cases we've succeeded in doing that already. We have our eye to some others. One of them, a big prize in that regard, if we can achieve it, is Glasgow, although there are problems about fitting all the business of both these courts into the one building there. But there will be others which in due course we shall come to and address in relation to what can be done. But it may be at some stage we will have to come to the Parliament and say, well, we think that certain steps should be taken, perhaps even closing some courts in the future.
Thank you for that answer. I'm just wondering, in speaking from my own constituency's perspective, a very rural area, in terms of the principles you're using to guide this decision-making process, is the rural nature of the area and also the transport links a valid principle, or is that included within the principles that you are considering?
I'd say we haven't actually formulated the principles there, but that certainly will be recognised. And one of the things that we did recognise also at a higher level is that we have to consider what we should be doing about the High Court. I mean, there's been a suggestion that the High Court should stop going on circuit. But I think the view that's coming through is that it's important that the High Court, as the most senior court in criminal business, should be seen to be operating across the community at large geographically, so that notions that we should simply do it in Glasgow, Edinburgh and perhaps Aberdeen have been rather put back. So we're looking at that matter as well.
Thank you. Got James Kelly, then Roderick.
Thank you, Convener, and good morning, Lord Hamilton and Miss Emberson. Lord Hamilton, you were quoted recently in the media as saying that cuts can never be permitted to compromise justice in our courts. In the submission to the committee from the Procurator Fiscal Society, they note concern that in terms of future years there are reductions in staff costs, and that currently they're seeing a backlog of 14,000 cases, which has increased from 7,000 in April. Would you not agree, therefore, that we've got an issue, potentially just now, of justice being compromised in our courts, and that could be compromised further by the staff cuts in future years?
Well, there are problems about that matter. I mean, we've had to address questions of staff cuts. We've cut down, I think, by just about 100 members of staff from something like 1,500 by a voluntary retirement scheme, which operated quite well. We have no notion of actually requiring people to retire, no compulsory redundancies or anything of that sort. We may be losing members of staff by a sort of natural process of not replacing people when they retire. We are very conscious of the fact that potentially, if you reduce the number of staff, the remaining members of staff will require to do more work. But we're also addressing other ways, such as computerization and other forms of information technology, which allow us to achieve this matter more efficiently. So far as the courts are concerned, I don't see that there is any particular problem so far as them processing cases are concerned, provided the Fiscal Service brings the cases to us. One particular matter which did give me some concern at one point, when the initial financial arrangements were announced in September, was that there seemed to be a greater cut being made so far as the court service was concerned than in relation to the Procurator Fiscal Service and in relation to the police. And you could give rise to an imbalance in that regard. If they get a lot more finance and produce a lot more cases much more quickly, we might be faced with a difficulty in processing them as efficiently as we would like. And I made certain representations at that particular time, and there was a certain adjustment made in relation to it. So one has to always bear in mind the effect of cuts in relation to what we can produce in the way of services. But I'm confident that we still will be able to adhere to doing justice in our courts, and that's critical.
One follow-up, Convener. You mentioned the early retirement scheme and the fact that there had been a reduction of 100 staff. Do you have a concern going forward if you reduced 100 staff, and clearly from the budget outlines there are going to be more staff reductions? Is there a danger that you're losing expertise as a result of these budget cuts, and that is going to compromise the ability to deliver justice in our courts?
Well, we use expertise. Perhaps the greatest difficulty is that often you get the people who are prepared to go voluntary are your most experienced members of staff. And that means that there are challenges for the more junior members of staff who are left to take over the reins of these particular matters. But if one does it in an orderly way, I think we can avoid the sort of problems that you envisage. As I say, we did this voluntary scheme last year. We have no plans to do one this year. So far as the future is concerned, we are envisaging simply natural wastage, as it were, but we may have to address the matter again at some stage.
As a brief supplementary to the information technology reference you made, the Law Society suggests using video conferencing in certain circumstances in court. How, Lord President, do you feel about that?
Well, we use video. Yeah, my recollection is that we do it. Eleanor, perhaps you could remind me of that. So I think they do it for commercial business in Glasgow. I'm not sure whether they do it in the Court of Session, do they, for commercial business?
I think perhaps occasionally. There is a cross-justice project, part of the Making Justice Work programme, looking at extending the use of video conferencing in a whole range of ways across justice, contacts between solicitors and clients who are in prison, contacts between courts and witnesses and so on. And over the next few years, I think we would intend to see quite a lot of extension of the use of video conferencing.
Yes, I mean, one area that's not been taken up, rather surprisingly, is a video link which exists between Glasgow Sheriff Court and Bargany Prison, and which we hoped that there would be an appropriate link between solicitors and persons in custody. It's not clear why that is so. I understand that the Scottish Legal Aid Board is taking up this particular matter and making an investigation to see why that is so and whether or not there can be some improvements made to allow that to be done more efficiently.
Thank you very much. I move on to Roderick. Sorry, Graham. So you're not. You're down at the bottom here.
It's just
this
a
is
supplementary
on
yes.
IT.
Yes, and it's for Miss Emberson, if you'd oblige. The video conferencing capacity has been there for a decade now, and I understand that it's been used on fewer than a handful of occasions over the last year. Is it not time, given the budgetary problems that we're currently facing, that a higher degree of priority is attached to video conferencing and that some form of encouragement should be in place to ensure that it's fully utilised?
I absolutely agree. I think the handful of occasions you're referring to is probably the Barlinnie link. We use video conferencing technology for a lot of things. We use it for vulnerable witnesses, and in fact we increasingly are using it for witnesses to appear if there are long distances and so on in a lot of cases. So it's being used perhaps more than that would imply, but we're all justice bodies acutely aware of the need to save each other money, and that's why this project, led by the Scottish Legal Aid Board, has been established. There is a sort of sequence in this of which of the many different ways you could use video conferencing you try to tackle first. And there is some thought by the Legal Aid Board that there may be something to do about the links between solicitors and clients in prison first as a good way of saving some money quickly for travelling expenses and so on. And then, while that's going on, we can also be investigating how we get better use of the links between courts and prisons and perhaps police stations and so on. So there is a real will to do something about it, but it won't happen in a few weeks, as you'll appreciate.
Okay. Thanks, Graham. Sorry about that. Roderick Campbell, followed by Hamza.
Convener, may I declare an interest as a member of the Faculty of Advocates? Lord Hamilton, you're reported as having said that there have been marked improvements in efficiency in the Court of Session and the High Court in the last year. I was wondering whether you thought that the downturn in the number of civil cases commenced in the Court of Session and Sheriff Court, reportedly down 17% on the 2009-10 figures in 2010-11 and 26% on the 2008-9 figures, gave an opportunity for improvements in efficiency by virtue of that downturn. Perhaps you could answer that question.
Well, I'm not sure whether whether reducing the amount of cases gives rise to prospects of greater efficiency. It might do. Interestingly enough, what we're achieving, and it's partly due to the downturn, is that we're managing to give parties in civil cases diets much earlier than we used to do. In the inner house, in the appeal court, in civil matters, we're giving diets within a few months, when the traditional matter was that if you went to the inner house, it would take you at least a year to have your case heard. So far as the commercial court, which is one of the jewels in our crown, as it were, that is has a lot of business, but we are managing to give quite reasonably early diets for cases which are at least not too complicated in the sense of requiring a matter of weeks for them to be heard. If you have a case which can be dealt with by a proof or a diet of debate in 2 days or even 4 days and wanted a diet, asked for it today, you will be able to get it quite early in the new year. So that is dealing with the matter quite efficiently. So there has been reductions to a degree in the civil business, and I suppose that is to some extent how we can achieve these earlier diets, and that's an aspect of efficiency. Sorry, Eleanor, something like that.
May I add something? Just on the ordinary civil cases, there was indeed a sharp drop in the number of ordinary civil cases registered between 2009-10 and 2010-11, but we saw an increase in the number of proofs and debates that proceeded. So it's important to understand that when you see the volume of business coming in, it doesn't necessarily translate into the same level of reduction for the business of the court.
Supplemental.
Of course you can.
Would either of you care to speculate as to where you see the trend going in the number of civil cases commenced?
It would be a pure speculation. I don't know, because it's very difficult to judge what causes increases or decreases in litigation. One of the things that one might have expected in some fields of the business is that in difficult economic times, the construction industry used to address itself to claims when it had nothing to build. It would seek money for things that it had built and more money for the things it had built, and you got an increase, a spike effectively in litigation. I don't know that we've seen it on this particular occasion, because the economic downturn has been such that even the construction companies are not prepared to hazard their monies in relation to perhaps doubtful litigation when they would have done on earlier occasions of downturn. So.
One further
yes,
very small point. It's to do with the principles in relation to the future of courts.
Yes.
I wondered, given the 65 million maintenance backlog, whether maintenance issues would be one of the principles that would be considered.
Well, as I think I mentioned, a very large proportion of our budget goes on maintaining of court buildings, and that's the maintenance of these court buildings. And so we have to bear that in mind as a real factor in relation to our thinking.
As a supplementary, when Lord President, you mentioned the Specialist Commercial Court.
Yes.
Lord Gill has proposed a Specialist Personal Injury Court, and I think, if I'm not paraphrasing the Dean of Faculty too much, he gave it pretty short shrift and thought that changes in processes would be more pertinent to saving money. Do you agree?
We've had in existence for 2 years or so now arrangements for personal injury cases, what we call Rule 43 cases, which came out of proposals which Lord Coulsfield made some time ago. And that has produced, so far as I understand it, a really quite efficient way of dealing with personal injury cases. It involves giving parties a timetable from the outset in relation to when things will happen and when they have to do things, and includes a compulsory conference some weeks before the diet of proof, so that every opportunity is used for securing settlement before the cases come to court. So I would have thought that works quite well. It doesn't necessarily involve specialist judges in the Court of Session. I think each and every judge who hasn't confined to other areas of specialty will have his or her share of doing personal injury work. That's not a bad thing, because I think it's quite important that most judges should have the opportunity of doing that. But the procedure is such, I think, which is quite an efficient way as things are at the moment, and I don't see any particular need for making a change in that regard. I think there may be something to be said for doing it as it's begun to be done in the Sheriff Court, where I think in Glasgow in particular, steps have been taken to identify personal injury judges, and that seems to be working quite well.
Thank you very much. And I move on to Hamza Youssef, to be followed by John Finney.
Good morning. I suppose it's somewhat related to the convener's question, but with the tight nature of the budget settlement, does that give greater priority to Lord Gill's reforms, in your opinion?
Well, in some respects it does, but I have to say that Lord Gill's reforms are something for the medium to the longer term, as I see it, because it, first of all, needs legislation, and secondly, it needs resources in order to put it into place, particularly for any transitional arrangements. I think what is envisaged in the longer term, if Lord Gill's proposals are implemented by legislation, is that we will have district judges, for example, who will be paid rather less than sheriffs are paid at the moment. We'll have fewer sheriffs and we'll have fewer senators. And therefore you would expect perhaps the total judicial budget to be, judicial pay budget to be rather less than it is. But there are going to be transitional arrangements that have to be put in place when you're going to have a mixture of all of these ranks, which I think will be quite costly. So I think in the medium term, it will be important to have the means somehow or other before the end can be achieved.
So maybe the government should bring forward legislation sooner rather than later to expedite the process.
Well, as I say, if it can find the means, that may be a very significant inhibiting factor in achieving it.
Sure. Well, thank you very much. That's very useful.
Roderick, is this a supplementary at that point?
I just wondered as to the extent to which you believe that case management could be improved without actually incurring substantial expenditure. That's one of the...
Yeah, well, I guess so far as the prime example of case management is commercial business in the Court of Session, and I think that can be said to have been a real success. It is an expensive thing. It's expensive for litigants, because if you're going to require litigants to appear regularly at preliminary hearings and other procedural matters, then it's going to cost them, because they've got to pay for the lawyers to be there. So I can see that there are advantages in that matter, but it does involve what's technically called upfront costs, so that people have to expend money at an early stage in litigation, hopefully to save money at a later stage.
On the point of litigants, do you foresee, with the changes in legal aid and perhaps the changed economic circumstances for people, that there may be more party litigants appearing? Do you have a view on that, and other cost implications when party litigants appear?
Yes, there are. I mean, I think there is a real risk that, just concentrating for the moment on civil business, that there will be more people who will not be able to get legal aid, and therefore more people who will have cases to bring, but will have no means of obtaining and paying for representation for these cases. And that means that we'll get more people as party litigants in our civil courts. That is a problem. It's a problem for the dispatch, for the fair dispatch of the business itself, because whatever people may think about lawyers, on the whole, lawyers are able to concentrate on what the legal issues are in the litigation. And lay people very often are unable to see the wood from the trees, the relevant from the irrelevant. What one often finds, and I've certainly found it myself, is that in many cases with party litigants, there is a mass of complaints being made. Somewhere in that mass there is a nugget, but it's a question of finding the nugget. And that involves quite a lot of judicial application to try and find it, to try and identify it, to try and address it, and try to solve it. That is likely to take more in the way of judicial time and resources to do that, and that consequently is going to have implications so far as the efficient dispatch of business and the costs of doing so are concerned.
Probably this is a question you may not be able to answer, but has anybody ever costed a case that has been presented by a party litigant? Do we have any idea of the additional costs to the system?
Don't think so. I think it would be a very difficult exercise to carry out. I don't think anybody has done it. No, this is just a matter of impression.
Thank you. Graham, you have a supplement on that topic.
We've heard earlier at hearings here about the interest in some form of resolution process prior to coming to court. From your perspective, do you think that we should be encouraging the development of that in a formal fashion? And would you see efficiencies and budget saving coming from that we would be able to invest in the future?
There are arguments either way. I think at one stage there was, in commercial business, a scheme which required parties to take certain steps before they were entitled to bring an action into court. I think that was drawing on some experience from south of the border. In the end of the day, that didn't work. It was found that it was much better to allow the case to be brought into court and to be managed subject to judicial supervision from an early stage. So I'm all for encouraging people to resolve their differences extrajudicially, and such encouragement as could be given in that regard is to be taken forward. But I'm not wholly convinced that taking formal steps of requiring this and that to be done at certain times is necessarily the answer to that.
John Finney, please.
Convener, it's back to a different subject touched on by John Lamont, if I'm better to interrupt you. Thank you. Lord Hamilton, thanks. I noted your comments earlier about not having formulated the criteria around which the court review would be.
Yes.
So can I make a suggestion and then perhaps pose a question? The suggestion is that you include carbon footprint as part of that, for the reasons alluded to by my colleague here. A few carloads heading up the A9 to Inverness as compared to busloads of witnesses heading down, and all the consequential hotel bills, etc. If that could be borne in mind, please.
That's Inverness, is it?
Well,
I feel that, John. That's
sincerely hope
Inverness.
so. But the point, of course, being one that you touched on there about access to justice and seen to be done. And with regard to that, I wonder, can I touch on another aspect which certainly should impact on any capital expenditure, but also revenue, and that is representations that have been made to this committee by the women's aid groups, and the issues of separation of witnesses from accused, and accepting that the physical layout of courts can't be changed very readily on occasions. Is there a budget line, or isn't that your consideration? Can you give us any indication if that's a thought? Because clearly we want victims of crime to come forward, and anything that would prohibit that is to be discouraged. Please.
Ask Eleanor to respond on that matter.
We have what you would call a court design guide, which is, if we were able to build a new court building anywhere, what are the principles we would use? And one of them is, exactly as you say, the separation, or proper separation of witnesses and victims and so on. And as you also note, an awful lot of our old buildings don't conform to the standard that we would like to set, and we will look at that when we're trying to decide. As the Lord President said, the court estate for the 21st century, one of the things we'll have to take into account is how far the buildings we currently have meet, or could be made to meet, the standard that we would really want them to meet. And that, I think, has to be part of the consideration.
If I may, then, can I clarify then, Emberson, is there actually a programme in place, if you like, a transitional programme between what the ideal is and what the reality is?
We've done it.
It could, in some instances, be very modest of using different entrances. Or,
Well, a lot of them. We do try to take that into account in all of the buildings at the moment. We don't have a single specific budget line that is purely for addressing security issues, but we have a health, safety and security committee that's very active, that looks at all of these matters, and we do act on the recommendations that they make. I think it sounds easy to say separate entrances. It turns out to be a lot more complicated than that in a lot of cases.
Thank you very much.
You've already referred to, Lord President, and Ms Emberson, to the cooperation, as it were, with regard to video conferencing with the Scottish Legal Aid Board and the Scottish Court Service. I'm just wondering what other cooperation is taking place with other cuts that are going to be made to the legal aid budget. How much is it, to choose the awful expression, joined up? So that together they're working and they're not in their separate pods dealing with the issues.
Well, that is a matter that we are very conscious of, and we regard it as very important to address. I think I mentioned already, we as a court service can't achieve things on our own. We are part of a larger justice community. And largely at Eleanor's instigation, we had a very successful gathering in the earlier part of this year, in which the chief executives of the court service, of the Legal Aid Board, and of the Crown Office and Procurator Fiscal Service came together and addressed a meeting which was attended also by members of the boards of these three organisations. And that was very interesting and gave rise to a number of ideas about future cooperation. And one of the things that we've done is working with the combination with the court, with the Crown Office and Procurator Fiscal Service, so far as managing buildings is concerned. Yes. In a sense, we've done a takeover bid in relation to managing some aspects of their buildings, which has resulted in efficiencies and savings. So it is very important that we should get together, and we are taking steps along that line. And
does that go to the Cabinet Secretary as well? That do you have a report at the end of that goes to the government, or?
Bridget Campbell, Director Justice, and a number of Scottish Government colleagues were also present at the event that the Lord President mentioned, and there is a Scottish Government-led programme that brings together all of this work, joining up efforts across all of the justice bodies, which is called the Making Justice Work programme. And I have to say, I've been 7 years in the court service, we are much better coordinated than we have ever been.
And at the end of this, are you able to project some savings to the system? I'm talking, at the end of the day, we're here to look at where the money can be saved. Are you able to project what kind of savings would be made? There's no point doing it if it's going to cost more and there's no savings.
No, indeed not. But I mean, a large part of this joining up is to make it possible for the various bodies to live within the cuts that we're currently facing. I mean, it's a little chicken and egg, this. It's not a case of we'll all do things and then miraculously we'll save more money. The money has to be saved, and we're doing things to make sure it's possible.
So you're told this is your pot, now tailor things to fit
Largely,
it, and that's what you've been doing. Yeah. Well, I don't see anyone else asking any more questions. James, I see every time I say that, I must stop saying it. There's a little hand goes up somewhere. 2 hands go up. James will be followed by Graham.
Thank you, Convener. Just when you thought you got to the end.
Exactly.
If we can just turn to the issue of tribunals. The Scottish Government is currently going through a process of reviewing the tribunals service in order to embed not only potentially tribunals that are within the competence of the Scottish Parliament, but also some reserved tribunals. Do you think that that process is realistic, given the fact that there's a 10% cut in the tribunals budget over the period of the spending review?
Well, this is slightly out with my field because at the moment the Scottish Court Service doesn't have any responsibilities for tribunals at all, although it's projected that at some stage there might be an amalgamation between the Scottish Court Service and any tribunal service that's set up. I don't know about the economics of it. Obviously there are difficulties if the budget is to be cut to that extent. I rather think it will be necessary to do something about setting up a Scottish Tribunals service, because at the moment we are in the difficult situation that the UK and GB tribunals, which operate in Scotland, as it were, in terms of administration, have been just thrust upon us, as it were, in Scotland from the Ministry of Justice, because it suits their business to combine the court service there and the judicial service. And we've got to deal with that, and we've got to deal with a variety of different domestic tribunals which have their own separate modes of administration. And I think it will be more efficient if there is some central organisation which provides services to the various tribunals. And that, I would hope, would be achieved. How readily it can be achieved and the money available, I don't know.
Graham?
Thank you. We received information from SPICE, the organisation here that gave us some of the research material that we utilise, and it indicated in the assessment of the solemn procedure cases that there had been a fairly significant fall in the number of cases being processed through the courts over the last 3-4 years, and amounted to roughly around 700 cases over that period, about 25% of the annual number. So presumably there should be savings within that kind of volume. I think my question is that, having listened to the discussions thus far, are you confident that in the coming years, the way budgets are going, very substantial fall in legal aid for defence solicitors and so forth, do you feel that you've got an action plan that will deliver not only the savings that will bring you in budget, but will also plan for the future, because budgets don't look too healthy in the longer term? So the cut in the number of cases, and then this notion of, is there an action plan that will deliver?
Well, there is a significant drop in the number of solemn cases, and we are conscious of that. We are conscious that we have to address the costs that arise in solemn cases as elsewhere. One of the things perhaps I should mention, particularly in the sort of medium term rather than the longer term, is that in order to achieve the budget restrictions, we have to look not only at the question of what monies we get from government, but what monies we raise from other sources. And that includes the question of court fees. And one of the matters that we've noticed is that there are marked differences between what's done in terms of recovery of fees and outlays from on the one hand, the Office of the Public Guardian, where they cover virtually 100% of their outlays, down to through the Sheriff Court, where they achieve, I can't remember what the figure is, about 80%, and then down to the Court of Session, which is rather lower than that. And it's plain, I think, that we shall have to come to the Parliament with a view to getting increases in the court fees that are recoverable, at least in line with inflation, but possibly going further than that. So although it looks as if the third year ahead, the third of the 3 years ahead, is the most particularly difficult so far as we're concerned, that is one of the mechanisms that we would hope to be able to assist us in meeting our restricted budget at that time.
May I just add, would you mind? I just
Yes,
quickly add something. The point about the sheriff's solemn cases, it's much the same as the point about the civil cases earlier on. There has been a substantial drop in the number of indictments, but the number of trials with evidence laid has actually increased over the period. So it's this difficulty of looking at runs of figures about trying to understand something about the volume of business the courts are doing. It's not driven simply by the number of indictments registered, it's driven by the number of trials that actually go ahead.
Grateful, thank you.
On a final point, I think, if it's in your hands, I see that the budget for judicial salaries rises only slightly throughout the spending review period, although these are, of course, settled at a UK level. Are there concerns amongst judges about the small rise in the budget for judicial salaries? If so, could this result in fewer judges in Scotland in the future, and does it matter?
A number of questions there. It does concern the judges, I think, at all levels of professional judges. One of the things that arises because their salaries are determined on a UK basis is that they are subject to the recommendation of the Senior Salaries Review Board. The Senior Salaries Review Board has done a number of reviews over the last few years, has on each occasion recommended, other than the most recent one, as each occasion recommended increases in judicial salaries, perhaps even just to keep up with inflation. None of that has been implemented by the government at all, and in fact judges are in real terms being remunerated significantly less than they were 5 or 7 years ago. That gives rise to that, and perhaps associated with that is the question of pension provisions. As you'll be aware, the UK government is addressing questions of pension, including judicial pensions, and there are some real concerns about what is being done in that particular field. That gives rise to a number of problems, not least of which is making sure that we encourage the best people qualified for the post to apply to be senators of the College of Justice. One of the problems that we had last year was that there was a competition, but the board, having interviewed a number of persons, found that none of those who had applied were suitable for appointment, and we've been in a situation where we've been running one judge short for the last year or so. That's a matter of real concern. Should it matter in relation to judicial salary? It may depend what one has in the way of a range of judges. If the Gill review is carried through to its ultimate, then you will get cheaper judges, as it were. You will get district judges who will be paid less equivalently than sheriffs are being paid for doing the sort of business, some of which is done by the sheriffs at the moment. So there are things on the horizon in which there may be a smaller judicial pay budget required, but it's still important that we should get the right people in the right jobs.
So it's not appropriate a pay freeze, as it were, for senators?
No, I mean we are conscious, as everyone is, that there are restraints which are applied to everybody, and we have to take our responsibility in that regard as well. But it should be borne in mind that for quite a few years now that we've not been kept up with inflation.
You have that on the record, Lord President. I don't know how sympathetic the public will be out there, but you have it on the record. I want to bring this to an end. Remember, Lord President has to be away at 10:30. Yes.
It's for Ms Emberson about her last reply about the number of trials and so forth. I was just thinking of the consequences of what you've said there. Going back to this cut in legal aid that's immediate and for the next 3 or 4 years, seems to me there's a hurdle there. If there's going to be more trials at solemn procedure and we've got a cut in legal aid, how do we match that up in this joined-up working environment?
I've said that there has been an increase. I don't know that I'm projecting that there will be a further increase in number of trials. How do we match it? Well, we have to match it as we go. Legal aid is demand-led. We work with the Legal Aid Board to understand what's going on, and the arrangements that have been put in place allow all of the justice bodies to react to what emerges as the patterns. And we can all put down our best guesses, but we don't know. And we're working at the moment on the assumption that the number of trials and so on will be flat, and we work with the Legal Aid Board to minimise the costs of that. Sorry, that's a vague answer.
Okay,
right, thank you. We're right on time. I want to thank both the witnesses for attendance. It's very, very useful. And can I say, I understand the Lord President is retiring in June. Am I correct? This may be a little premature, but I think the committee would hope to wish you well in your retirement, unless you're before us again. Who knows? Thank you very much. Thank you.
Just to end up by making a reference to something which I think was said to you in your last session. I think maybe the Dean of Faculty used the metaphor of musical chairs, and they suggested that perhaps all that was being done was an exercise in musical chairs. I'm not sure the metaphor is wholly apt, but I don't think we've got a situation in which chairs are being taken off one at a time. What I do think is that we have the same number of chairs, but they're smaller chairs and less comfortable to sit in.
And on that, I suspend for 5 minutes. Thank you very much.